Hello, good afternoon everyone, and welcome to the Contentious Probate Update, which is being put on by the Bristol branch of STEP, Star Society of Trust and Estate Practitioners. My name's Alex Troup. I'm a barrister at St John's Chambers, and I'm delighted that so many of you are able to join us today. I think we've got up to 175 people who had signed up to this course, and the fact that so many of you are interested in it is testament to the high quality of speakers that we've got for you today. The star of the show is, of course, His Honour Judge Paul Matthews, who's our local Chancery Judge, and he's going to be speaking to us about testamentary capacity, which is an issue which seems to be cropping up all the time at the moment. I've even had the privilege of arguing it in front of His Honour in the past, albeit unsuccessfully. So it'll be extremely interesting to hear his take on a subject which seems to crop up so regularly in practice. After him, we have Christopher Jones from my chambers, a barrister who will be very well known to many of you, who has a chancery practice, and that involves a very significant element of contentious probate work. And he'll be talking to us about a practical guide to how to run a successful undue influence claim. Again, undue influence is something that seems to crop up perhaps more in instructions than it does by the time you actually get to trial. But Christopher will be drawing on his recent experiences to give us a practical guide as to how to run those kind of claims. And following that, we're going to have a question and answer session. So there's a chat function that you should be able to see on your screen. And please feel free to write any questions you have on that chat function, and we'll keep an eye on that. And then we can put your questions to the speakers at the end. But before all of that, we have a brief AGM for our local STEP branch, which is going to be run by Nathan Rollings, our chair. So Nathan, over to you for the AGM.
Thank you very much, Alex, and good afternoon, everybody. As Alex said, I'll try and keep this as brief as possible so that we can commence with today's session. And just a reminder that this AGM only applies to those of you who are members of STEP Bristol. It goes without saying that it's been an incredibly challenging year for all of us as a result of the impact of COVID. STEP Bristol had to cancel the last two events of our 2019-20 programme, which is why the 2020 AGM has been delayed until now. We've been busy in planning for the 2020-21 programme of events, which inevitably will be all held online, and more details of those events will be circulated to you all shortly. I have circulated the year-end finances for 2020 to the membership in advance of this meeting, and we would have seen from those that we have healthy cash reserves of approximately £14,000 to use on future events. The events that we did manage to hold in 2019-20 did not incur any costs in terms of paying for speakers or venue hire, which has resulted in a significant saving for the branch. Our student numbers have remained buoyant, and I'd like to offer my congratulations to all those students who have passed exams over the last year in what were unusually challenging circumstances. We wish you all the very best for your future careers as trust and estate practitioners, and look forward to welcoming you to future STEP Bristol events. There have been a number of changes to the STEP Bristol committee this year, with Katie King and Julian Frere stepping down from the committee, and I'd like to place on record my thanks to them for their assistance over the last 3 years. We were also very sad to see Angela Thomas retire from the committee and private practice during the course of the year. Angela had been a member of the Bristol STEP committee for over 15 years and had occupied every role on the committee during that time. We wish her all the very best for her retirement. And that finally brings me on to the committee positions for 2020-21 year, and the proposed positions are as follows. The chair will be Susie Pawsey, who's replacing myself after my 4 years in the role. Vice chair will be me, replacing Florence Pearce. Secretary will be Lucy Parrock for her 5th year in the role. Treasurer Austin Gill for his 6th year in the role. And the remaining committee positions will be occupied by Alex Troup, Gwyn Pritchard, Sarah Anthony, Florence Pearce and Louise Hendy. If anyone has any questions or objections to those positions, then please do contact me separately. Thank you very much all for your time. That concludes the 2020 AGM for STEP Bristol. It now gives me great pleasure to hand to Judge Matthews for today's session. Thank you.
Good afternoon, everyone. It is afternoon now. Yes, I can say that. I'm very pleased to have been asked to speak to you today about contentious probate. And the subject that I have chosen is testamentary capacity, with the subtitle, Now You See It, Now You Don't. Wills, in some ways, bring out the worst in people. Disappointed beneficiaries prefer not to see the cause of their disappointment in the testator's decision to give the property to others than them, but instead to some external cause. For example, undue influence, which Chris is going to speak about later, fraud, want of knowledge and approval, and of course, testamentary incapacity. The testator cannot really have meant this. There must be some other reason for the will as it is. And sometimes it's that the testator didn't have capacity. Here is a good local example from admittedly 65 years ago, shows that nothing changes. The testator's will left the residue of his estate to the Bishop of Bath and Wells, that worthy local prelate, to be applied towards the reconversion of the inhabitants of Wookey. I don't know what the inhabitants of Wookey had done to deserve this, but anyway, that's what he wanted his money spent on. 4 months after making the will, he was certified insane. Subsequently, he died, and after his death, his nephew, I think was his closest relative, applied to revoke the probate for testamentary incapacity. And the claim failed. The judge actually said, as I've set out at the bottom of the screen, the action was not merely a damp squib, it was a squib that had no powder in it at all. Nevertheless, nothing ventured, nothing gained. The nephew asked for at least for his costs to be paid out of the estate on the basis that it was all the old man's fault anyway for putting it in his will. And the judge, Mr. Justice Arthiam Davies, a judge then of the Probate, Divorce and Admiralty Division, said, too many actions are begun by those who are disappointed under wills on the basis of trying to get something from the beneficiaries. So that was that. As I say, nothing other than illustrating the fact that nothing changes very much. We still have the same kinds of arguments today. So what are the requirements for a valid will? We can pass through this quickly. The formal requirements are set out in section 9. We're not interested in those today. The substantive ones are that the testator should have capacity, should know and approve of the contents, there should be no undue influence, and there shouldn't be any fraudulent calumny, which is a very exciting concept which I had occasion to deal with just recently. But today I'm going to deal with the substantive requirement of testamentary capacity. What is the test for testamentary capacity? Well, the standard classical test is that set out by Sir Alexander Cockburn, Chief Justice, in Banks and Goodfellow in sterling Victorian language in 1870. He said, "It is essential that a testator shall understand the nature of his act and its effects, shall understand the extent of the property of which he is disposing, shall be able to comprehend and appreciate the claims to which he ought to give effect, and, with a view to the latter object, that no disorder of the mind shall poison his affections, avert his sense of right, or prevent the exercise of his natural faculties, that no insane delusion shall influence his will in disposing of his property, and bring about a disposal of it which, if his mind had been sound, would not have been made." Now, all that sounds very well, and it's very fertile ground for litigants to pick over and say, well, look, you know, he had this insane delusion, thought he was Napoleon or whatever it is, therefore he had no capacity. But it's not really as simple as that. First of all, there is, as the books make clear, there is no need for the testator to be nice to anybody. I said this in Ball and Ball, but this is well established long before that case. But this does not mean that the law requires a perfectly balanced mind, nor does it mean that a testator who is capricious or spiteful or mean cannot make a will. In principle, and subject only to the jurisdiction conferred upon the court by the 1975 Act, a testator with testamentary capacity and free from undue influence is entitled to leave his property to whomsoever he wishes. So far, so good, you may say. But of course, in 2005, Parliament enacted the Mental Capacity Act, which set out a different test for lack of capacity, although it was general and not referring specifically to the capacity to make a will. So the question began to be asked after 2005, is Banks and Goodfellow still the test? And there were a number of cases which, fortunately for everybody here, I am not going to go through, but they run from about 2009 through to one of my own again in 2018. And the convention is that you follow the last one decided at first instance, which happens to be mine. And I decided that the Mental Capacity Act did not apply to the test for testamentary capacity, and that Banks and Goodfellow still did. So far as I know, no one has challenged that that I'm aware of, but of course it has not, as a question, yet been dealt with at Court of Appeal level, and the Court of Appeal may of course take a different view. But on the assumption that Banks and Goodfellow is still the test, there is an important presumption which applies in these cases. And in the marvellously named case of Goss, Custard and Templeman, which I shall be coming back to shortly, Mr. Justice Fancourt this summer made clear how this presumption works. He said this: the parties in this case agree that the legal onus of proving the validity of a disputed will falls on the party propounding it, and that if a will, should really be but that if a will, is rational on its face and duly executed, there is a presumption of testamentary capacity. Accordingly, the initial evidential onus is placed on the defendants to adduce some evidence capable of showing that the deceased lacked testamentary capacity. If that onus is discharged, the evidential onus reverts to the claimants to prove that the testator did in fact have testamentary capacity. However, the modern approach is to address the question of capacity as an evaluation of all the evidence available to the court at the trial. So there is the position: if the testator makes a will which is duly executed in accordance with Section 9 of the Act, and it's rational upon its face, it is presumed that the testator had capacity to make it. But that capacity is not quite as difficult to attain as you might think, because there is an important distinction between the question whether the deceased was capable of appreciating something and whether he or she actually appreciated it. Again, from Goss Custard, Mr. Justice Fancourt said, it is important to note that where in the Banks and Goodfellow formulation reference is made to the understanding or comprehension of the testator, that is not a reference to what they actually remember, but rather a requirement that they have the capacity to understand and comprehend such matters. Capacity depends on the potential to understand. It is not to be equated with a test of memory. And then a couple of paragraphs later, the judge went on, the Court of Appeal in Simon and Byford expressly held that capacity does not require a testator to remember the terms of a past will that they made or the reasons why it provided as it did, as long as they are capable of accessing the information if needed and capable of understanding it if they had been reminded of it. Lord Justice Lewison, with whom the other members of the court agreed, held that it was not necessary for a testator to understand the collateral consequences of disposing of assets in one way rather than another, as distinct from the direct consequences. Now, what all this means is that testamentary capacity is necessarily quite a low standard, a lot lower than lay people think. People come to your office or come and see counsel and say, my old mum, she's made a will and it's not leaving everything to me, so it's completely doolally. And of course, they don't realise that it's necessarily a low standard for capacity, otherwise old people wouldn't be able to make wills very often. And naturally, judges being elderly people, that would never do. So this brings me on to an important point, which is raising its head more and more often today, and that is the role of mistake in capacity. Lay people say, well, look, this is mistaken. He didn't own this, or she meant to give it to somebody else, or she's referred to her niece as her nephew, or something like that. And this shows that they had no testamentary capacity. Well, I dealt with this very briefly in the case of Ball and Ball, which I mentioned earlier 3 years ago, which was a very sad case where there was a complete falling out between siblings, as so often happens. And one of the points made was that the testatrix, their mother, had made a mistake in believing something which they said, or the claimant said, was not true. In fact, sorry, other way around, that the defendant said was not true, but the claimant said was true. Now, there was a case called Rebellis, which referred to mistake, and this was discussed at the hearing. And I said this about that case: in my judgment, Rebellis makes clear that mistake does not by itself operate to invalidate a will. What it can do, however, is to provide a basis upon which to say, in an appropriate case, that the testator either is suffering from an insane delusion or does not possess a sufficiently sound memory for the purposes of making a will. But a mere mistake without more is not enough. And this point was dealt with in much greater detail and more fully by Mr. Justice Fancourt in Goss, Custard and Templeman. Now, this case concerned the will of the late Lord Templeman, who, as you all know, was a very famous Chancery judge, finding his way all the way up to the House of Lords. And he had made a will in which he had left the house in which he was living before his death, Mellowstone in Exeter, to his stepdaughters, that is to say, the daughters of his second wife, rather than to his own sons by his first wife. And the second wife had predeceased him, and she had been the owner of Mellowstone, and she left it to Lord Templeman in her will, and he decided in his latest will, which was the one challenged, that he would leave this back to the stepdaughters. Apparently, according to the two sons, or one of the sons at any rate, forgetting that he and his wife, second wife, had agreed that it should be split between the two sides of the family. That's the argument anyway. And Mr. Justice Fancourt said this: I find it difficult to accept that Lord Templeman's thinking in August 2008 involved an illusory belief. His focus was on where he felt at that time that Mellowstone should go after his death. He had forgotten, on this hypothesis, that he and Sheila, that's the second wife, had previously agreed that it should be divided. But even if this amounted to or involved an illusory belief, it falls far short of the kind of delusion needed to negative testamentary capacity. It was merely a failure of memory about previous intentions or about circumstances relating to potential testamentary objects. And then he said this in the following paragraph: the defendants rely heavily on a case called Rebellis for the proposition that an illusory belief is equivalent to a delusion for these purposes. In that case, an elderly testatrix made a last will in secret in which she departed for the first time from equal provision for her two daughters that she and her husband had made in previous wills and in lifetime gifts. The last will professed to provide equality in her dealings with her daughters. In fact, it did not, because the testatrix was subject to a mistaken impression amounting to a delusion that for years she had given more financial assistance to one daughter than to the other. And he examined the case of Rebellis and said, what is clear from this decision is that the president, that is to say the president of the Probate, Divorce and Admiralty Division, found that Mrs. Bellis was subject to, if not an insane delusion in that she was not insane, then an illusory belief of such a character as to negative testamentary capacity. She did not have the mental powers to enable her to recall and understand the true dealings between her and her daughters. This was not a case of a mistaken belief that was capable of being corrected. It was a case of an illusory belief from which Mrs. Bellis could not be shaken and which deprived her of her reason. I therefore reject the suggestion that Re Bellis stands as authority for the proposition that a mere mistaken belief, which is the product of forgetfulness, is inimical to testamentary capacity. Now, one of the ironies of this case is that there is a well-known rule in probate cases known as the Golden Rule, which was first introduced in a case called Kenwood and Adams, and then followed up by another one called Re Simpson, both decided by the youthful Mr. Justice Templeman. And in Key and Key, Mr. Justice Briggs described the Golden Rule in this way. The substance of the Golden Rule is that when a solicitor is instructed to prepare a will for an aged testator or for one who has been seriously ill, he should arrange for a medical practitioner first to satisfy himself as to the capacity and understanding of the testator and to make a contemporaneous record of his examination and findings. And as I say, the ironical thing about Goss, Custard and Templeman was that the solicitor in that case did not follow the Golden Rule, and perhaps as a result we had the litigation. Now, the Golden Rule does not mean that if it is followed there can be no challenge to the testamentary capacity of the testator. It is simply that it is a good rule of practice to do this, and that will provide quite possibly a good reason why litigation does not take place following the death of the testator. So if you do have a situation in which there is no medical evidence contemporaneous with the making of the will, you will need, if you're going to fight a case on testamentary capacity, to have evidence which persuades the court of the lack of capacity. And for that purpose, you're almost certainly going to need to have an expert. The role of expert evidence is something I'm not going to spend any great time on because it's something which everybody knows about. But I point out that for present purposes, an expert instructed after the deceased's death is unlikely to have examined the deceased during life. And so the opinion evidence, the expert opinion evidence which that expert gives will be based on facts which have been established by others. There are rare cases in which the Golden Rule is followed by sending the patient off to see Professor X or Dr. Y, who is a well-known expert on this question, because the solicitor really is afraid that there will be a challenge in the future. But they are very rare cases indeed. You can count them on the fingers of one or possibly both hands. The expert evidence will obviously have to be given in accordance with the rules of CPR Part 35. I'm not going to say anything about that. Those are too well known for today. What kind of expert will you want? Well, as a general proposition, a general practitioner is not going to be sufficient unless that general practitioner has got some particular geriatric psychiatry expertise. And there are GPs who do have that. And there are diplomas that they can take, further education and so on. And that may well be a way of getting the right kind of expert. But usually the kind of expert that is obtained in these cases is an old age or geriatric psychiatrist who knows about the process of aging and what it does to memory and ability to obtain, retain, hold in your mind information which you need in order to make a will. It doesn't have to be an old age psychiatrist. Sometimes it's appropriate to have a different specialism. For example, if someone has been suffering from a brain tumour, you might want to have an opinion from a neurologist who can speak to how that kind of brain tumour affects the thinking process. It all obviously depends on the circumstances. So one of the things that I have concentrated on is the low standard of the capacity actually required. Another is to emphasise that mistakes in themselves are not going to get you home and show that there is no capacity. It's got to be something which really goes a long way further. And I want to essentially draw my remarks to a close with a rather remarkable case about capacity that seemed to come and go. And it's the case, perhaps not as well known as it might be, of Park and Park, decided in 1954. Now, the plaintiff in this case married the deceased, who was then aged 78, at 11 a.m., note that, on the 30th of May 1949. The deceased made a will at 3 p.m. on the same day. After the deceased's death, which took place on the 17th of June 1949, the plaintiff successfully claimed in an earlier probate action in 1950 that the deceased had lacked capacity to make it. You may say, why on earth did the plaintiff do that? And the answer was she wasn't satisfied with the provision that was made for her, and she didn't think she could get anything else except by having the will set aside. So she succeeded in a probate action in having that will set aside on the basis that the deceased lacked capacity to make it. And because she was the deceased widow, she now wanted letters of administration to his estate. This was challenged by the defendant, who was the principal beneficiary of an earlier will dated the 1st of March 1948. He claimed that the deceased had no capacity to marry on the 30th of May 1949, and so the plaintiff couldn't be his widow. End of story. Ha ha ha. Well, the Court of Appeal dealt with this case. Lord Justice Birkett made the obvious point. He said most people, without giving thought to the matter, would say that if a man was in fact of unsound mind, memory and understanding at 3 o'clock on the day of his wedding, it does not want very much to show that 11 o'clock on that day he was not fit to be married. And you might have thought the same. At first instance, in this case, Mr. Justice Karminski had said that the evidence was very conflicting on whether he had capacity to marry. He also suggested in a rather off-key remark that there might be a difference in the capacity required to get married and to make a will, but the Court of Appeal pooh-poohed all of that and concentrated on the actual facts. The judge had held, in my view, the conflicting nature of the evidence can be largely explained that from the summer of 1948 until his death in June 1949, the condition of the deceased varied from day to day, and sometimes, as Dr. Urwick found, almost from hour to hour. So, as Lord Justice Birkett concluded in the Court of Appeal, Mr. Justice Karminski, in coming to his conclusion, quite palpably had every one of those conflicting matters in mind, and most of all, this variation from day to day and from hour to hour. In these circumstances, I do not feel that it is possible to depart from that decision, and this appeal ought to be dismissed. So the result was that the deceased had had capacity to marry at 11 and no capacity to make a will at 3. We live in interesting times, and I hope that you will have found this an interesting reminder of the problems that arise in relation to proving or disproving testamentary capacity. Thank you all very much indeed for your attention.
Good afternoon, everybody. I'm now going to speak to you briefly about undue influence claims. Undue influence, as the judge says, is often an argument that's advanced by clients seeking to challenge a will, particularly where they feel that the testator, free of influence, could not possibly have cut them out of their estate. Naturally, as with many will challenges, it's a deeply emotive subject, perhaps because it requires the parties to allege and prove influence or undue influence over another, which is beyond the usual bounds of propriety and trespasses into the improper and immoral in some cases. Now, as one would expect and hope, the courts take these claims very seriously indeed. And in wills cases, evidence of actual undue influence is what is required. So bringing a successful will challenge on the grounds of undue influence is therefore notoriously difficult. In a probate claim, undue influence means coercion. That is to say, the testator was coerced into making a will or part of a will which he did not wish to make, and the level of influence required will vary from case to case. Persuasion is legitimate, coercion is not. And going back to the 19th century line of cases, a particular case called Hall and Hall comes up from time to time, and the comments of Sir J.P. Wilde explain the position. He said, to make a good will, a man must be a free agent, but all influences are not unlawful. Persuasion appears to the affection or ties of the kindred, to a sentiment of gratitude for past services, or pity for future destitution or the like. These are all legitimate and may be fairly pressed on a testator. On the other hand, pressure of whatever character, whether acting on the fears or hopes, if so exerted as to overpower the volition without convincing the judgment, is a species of restraint under which no valid will can be made. And he sums it up rather pithily when he says, in a word, a testator may be led but not driven, and his will must be the offspring of his own volition and not the record of someone else's. So that's the sort of the backdrop to these claims, and that theme comes up time and time again. And although they talk about force and coercion, they sometimes plead in the alternative and undue influence claims, but they are really two sides of the same coin. And the claims that we see from day to day or month to month can vary wildly. At one end of the spectrum, the extreme end of the spectrum, one will see allegations of physical violence, threats of violence, confinement or imprisonment, for example. And on the other, and perhaps probably more commonly, that the pressure exerted might be of the form of talking incessantly to a weak and feeble testator, that sort of drip process of influence. Might even be talking to the testator at a stage of an illness where they're particularly weak and unable to do anything, and for the sake of quietness, they simply give in. And that's certainly what we see in some other cases that I'll talk to you about shortly. Now, and I should just add one quick word. I see no reason in principle why undue influence in a probate claim can't be economic or economic coercion or duress, as perhaps one would see in a contract claim. And coming back to another 19th century case called Wingrove and Wingrove, Sir James Hannan summarised the position in a jury speech. These cases were tried by juries then, in a fairly useful way. He said this: to be undue influence in the eye of the law, there must be, to sum it up in one word, coercion. It must not be a case in which a person has been induced by means such I have suggested to you to come to a conclusion that he will make a will in a particular person's favour, because if the testator has only been persuaded or induced by considerations which you may condemn, really and truly to intend to give his property to another, though you may disapprove of the fact, yet it is strictly legitimate. It is only when the will of the person who becomes a testator is coerced doing that which does not cite that is. Now, this is meant to be a slightly updating talk, so I think I'll talk now to you about a 19th century case called Craig and Lamoureux. In that case, Viscount Haldane, citing a 19th century authority, summarised the position as follows. In order to set aside with us a sound mind, it's not sufficient to show that the circumstances attending to its execution are consistent with the hypothesis of it being obtained by undue influence. It must be shown that they are inconsistent with a contrary hypothesis. Undue influence, in order to render a will void, must be an influence which can justly be described by a person looking at the matter judicially to have caused the execution of a paper pretending to express a testator's mind, but really does not express his mind, but something else and someone else's, which he did not really mean. So that's all very interesting, but this is meant to be a practical guide to bringing claims. So how do we go about proving it? In wills cases, the burden of proving a will lies on the person who propounds it, as the learned judge has said. It's typically achieved by showing that a will was properly executed, complied with Section 9, and that the testator had testamentary capacity. Now, where these two matters are shown, it's then for the party alleging undue influence to prove it. As I've already explained, there's no presumption of undue influence. Allegations of undue influence are pretty serious. It doesn't come much more serious in the probate world, perhaps forgery on a similar keel, but undue influence is pretty serious as it goes. So accordingly, if the court's going to infer undue influence from the context, it needs to have fairly cogent evidence to do so. There's a case from 1996 that came before what I was about to say the Supreme Court, would have been the House of Lords then, called Re-H, where Lord Nichols considered the approach of the civil courts to applying the civil standard of proof to allegations of fraud and wrongdoing. And he explained it as follows. The balance of probability standard means that a court is satisfied an event occurred if the court considers that on the evidence, the occurrence of the event was more likely than not. When assessing the probabilities, the court will have in mind as a factor to what extent is appropriate in the particular case, that the more serious the allegation, the less likely it is that the event occurred, and hence the stronger should be the evidence before the court concludes that the allegation is established on the balance of probability. Fraud is usually less likely than negligence. Built into the preponderance of probability standard is a generous degree of flexibility in respect of the seriousness of the allegation. Although the result is much the same, this does not mean that where a serious allegation is an issue, the standard of proof is higher. It means only that the inherent improbability or probability of an event itself is a matter to be taken into account when weighing the probabilities and deciding whether or not on balance it occurred. So, we're unlikely to get direct evidence because the best witness of undue influence is going to be the testator, and given that you're fighting over his will, he or she's going to be dead. You're unlikely to have the wrongdoer confessing before you that he's unduly influenced the testator into executing the will. So we're proceeding with inference from the circumstances surrounding the execution of the will. Now, there are a whole raft of authorities going back to the 19th century and 18th century, in fact, which record challenges to wills for undue influence. I've mentioned some of them already in this talk, but the list of successful claims is, as you would expect, considerably shorter. And it's only in relatively rare cases that challenges to wills for undue influence will succeed. Excuse me. A good example, excuse the pun, is a case called Re Good. Carapetto and Good is a relatively recent, in the grand scheme of things, case from 2002, and it's an example of a failed claim in undue influence. In that case, the testatrix was elderly. She'd made a series of wills in the last years of her life, which left varying sums of money to her nephews and other members of the Carapetto family. By all accounts, the Carapetto family had been pretty good to Mrs. Good. They'd looked after her, they'd cared for her needs, but certainly towards the end of her life, there was a bit of a breakdown in relations between the Carapetto family and Mrs. Good's extended family. In her final will, she left some small pecuniary legacies and specific legacies, but the rump of her estate went to the Carapetto family. The Good family challenged the will on a number of grounds, but specifically they argued undue influence. They argued that in the preparation of her third will, the testatrix had instructed a different firm of solicitors, a firm that had been instructed by the Carapettos, which is often seen as a red flag in these cases where a vulnerable party moves away from a long-established firm of solicitors who'd acted for them for a long period of time to a new firm. Secondly, they argued that during phone calls with the new solicitor, Mrs. Carapetto had prompted the testatrix to give her certain instructions, again, something of an alarm bell. And they argued that when the family had made efforts to see Mrs. Good in the last days of her life, the Carapettos had essentially made it, if not impossible, incredibly difficult to see her. And they said by inference, one can draw from all of those surrounding circumstances, Mrs. Good had been unduly influenced into executing this new will. Mr. Justice Reimer, as he was then, said as follows: in my view, the wholesale overbearing of a testator's will by coercion is an inherently more improbable event than, for example, the bringing to bear on the testator of legitimate persuasion of the type referred to in the Hall case. And I bear that in mind in assessing whether, on the evidence, the defendants have discharged the burden of proving coercion. And Mr. Justice Reimer concluded that the Good's evidence that the Carapettos had coerced Mrs. Good into making the last iteration of her will was insufficient. But the judge did note that the absence of direct evidence of undue influence and acknowledged that in many cases it's possible to proceed by inference, but the evidence here was insufficient to support that inference. Moving forward then 5 years to a slightly better known case called Edwards and Edwards, a decision by Mr. Justice Lewison, as he was then, a High Court case. The court was faced with another elderly testatrix who had initially left her estate equally to her 3 children. One of her 3 children, Terry, lived with her, He was a heavy drinker, and there was evidence that the testatrix was afraid of him. She suffered a fall and was admitted to a nursing home. Terry removed her from the home, contrary to the medical advice at the time. During that period after leaving the home, the testatrix changed her will. In so doing, she left everything to Terry. She told the solicitor who prepared the will for her that he'd done everything for her. Now, at trial, that seemed to be palpably untrue. In fact, Terry had done very little for her at all. In fact, it was her son and her daughter-in-law who took care of her almost entirely. In that case, unsurprisingly, undue influence was made out and the will wasn't admitted to probate. But rather helpfully, Mr. Justice Lewison summarised a few key features of a successful undue influence claim, I should say, and this is a theme that runs through lots of the authorities that followed. Firstly, he reminded himself that there's no presumption of undue influence in wills cases, as there is in certain lifetime transactions. He said whether undue influence has been procured, the execution of a will is a question of fact at all times, and the burden of proving that fact rests on the person who asserts it. And he said as follows: in this context, undue influence means influence exercised either by coercion, in the sense that the testator's will must be overborne, or by fraud. Coercion is pressure that overpowers the volition without convincing the testator's judgment. It is to be distinguished from mere persuasion. The physical and mental strength of the testator are relevant factors in deciding how much pressure is necessary in order to overbear the will. The will of a weak and ill person may be more easily overborne than that of a hale and hearty one. And then he said, summarising the position as follows: the question is not whether the court considers the testator's testamentary disposition is fair, because subject to the statutory powers of intervention, a testator may dispose of his estate as he wishes. The question in the end is whether in making his dispositions, the testator acted as a free agent. So there's just one useful theme I'd like to pick up on there before we go any further, and that's the issue of this. The judge said that the physical and mental strength of the testator are relevant factors. So I'm just picking up on Judge Matthews' talk. If you're bringing a probate claim and you are considering a challenge on testamentary capacity, and you have some evidence that points to undue influence, it might be the case that the testator had testamentary capacity, but where that capacity is reduced and not quite as perhaps the same as a fully capable testator, there may be just enough in that expert report to assist in your challenge on undue influence, to show that the person is more vulnerable or more susceptible to pressure or influence. There were a few more intervening cases, a case called Cowdroy and Cranfield with Alex Stard, and a case called Schwamberg and Taylor from 2013. But I want to talk to you now about a case called Schrader and Schrader. This is another High Court decision, another elderly testatrix. Mrs. Schrader was a 98-year-old widow. In 2006, she executed a will, leaving her home to her two sons, to one of her two sons, a gentleman called Nick, and left the residuary estate to her other sons equally. In her earlier will, she left her entire estate equally to her two sons. This was a decision of Mr. Justice Mann. Now, again, the judge reminded himself, as have many of the judges in the case that I've taken you to this afternoon, that rarely will there be direct evidence of undue influence, and usually we're proceeding with establishing the evidence from inference from the surrounding circumstances. And Mr. Justice Mann was prepared to infer undue influence in this case, and he set out a fairly helpful list of factors from which he was able to draw that inference. Firstly, at front and centre of his judgment was the fact that the testatrix was vulnerable. He pointed out that the testatrix was dependent largely upon the wrongdoer, who stood to gain from the challenged will, his son Nick. He pointed out that her long-standing solicitors had not been engaged to prepare the challenged will, and that the evidence before the court indicated that the testator's reasons for leaving her house to her son Nick were inaccurate. And what's more, the source of that information was her son Nick. Next, he pointed out there was no other reason given in the papers before the court, certainly in the solicitor's attendance notes, which would explain why the testatrix wished to change her disposition of the house in favour of Nick. And interestingly, the judge went on to say as follows, commenting on Nick as a character. He said Nick was, quote, a forceful man with a forceful physical presence. I repeat that I find that there was no question of physical abuse or even real emotional abuse. I'm sure that he will have experienced frustrations in looking after his elderly mother, which many less volatile personalities would experience. However, the fact is he was a powerful personality and his mother was more vulnerable. And that weighed heavily on the judge's mind when he was weighing up the evidence and considering whether or not Nick had unduly influenced his mother. And if you like, the final nail in the coffin of Nick's case was what happened after his mother passed away. Rather than producing the will and brandishing it and saying he wanted to admit it to probate, he sat on it for 6 months until after a while he produced it and argued that it was his mother's valid will. The court found this highly suspicious indeed, that he would sit back and do nothing with the will until 6 months had passed. And moreover, the court wasn't terribly impressed when Nick sought to distance himself from the will-making process and claimed that he knew very little about the will, when on evidence at trial it became quite apparent he was closely involved and knew fully what his mother's will said. So that was the position until 2019. And then last year, a fairly high-profile case came before His Honour Judge Jarman in Cardiff, a case called Re Chin 2019. Now, this is an interesting case because, again, it's an elderly, vulnerable testatrix. But rather than the party putting influence on her being one of her sons, it was one of her sons, but it was also her husband. Mrs. Chin had been placed under considerable pressure by her husband in particular to leave certain assets of hers to her male line. His Honour Judge Jarman, again commenting on the distinction between permissible pressure and undue influence, said as follows: what is not permissible is for the pressure or persuasion to be such that Mrs. Chin succumbed to it for the sake of a quiet life, to the extent that it overbore her wishes. In deciding whether that line was crossed, in this case, a number of factors are, in my judgment, particularly relevant. And again, like the Schomburg and Taylor case, His Honour Judge Jarman listed a few factors which he considered to be particularly relevant here. In no particular order, that list included. The judge found that in 2009, Mrs. Chin was so worn down and distressed by the relentless pressure to alter her will, she was complaining to members of her family about it. In August 2010, she was moved from her home of 30 years, an event which, on the evidence, she found to be particularly traumatic and distressing and unsettling. There was fairly cogent evidence of there being friction between her husband and her daughters concerning the pressure that he was obviously putting his wife under to change her will. Mrs. Chin's grasp of English was particularly poor, and she was dependent upon her son and her husband to translate documents for her. And finally, her son had organised the meeting with the solicitor and took his parents to that meeting and took them away afterwards. Concluding, the judge said as follows: in my judgment, the resilience which Mrs. Chin had shown in 2009 as to putting into effect her wishes was, by the end of 2010 or the beginning of 2011, worn down by such pressure and to such an extent that the 2011 will represents her husband's wishes and not her own. It is likely that her desire to avoid family squabbles and enjoy a peaceful life played a large part in her succumbing to those wishes. In my judgment, the factors set out above, taken together, are inconsistent with any other conclusion. And that's a theme running through the various judgments that we've looked at this afternoon. It's very often difficult to have direct evidence of undue influence being placed on a party. The Chin case was quite an extreme one because the family members were willing to come to court and recount evidence of Mrs. Chin having been directly put under that sort of pressure. But when one's proceeding with inferential evidence, the court has to weigh up the evidence, weigh up the factors, and decide whether or not the conclusion that you're being asked to draw is inconsistent with any other conclusion. So then, as I said earlier, this is meant to be a practical guide, so I'll close off my section of today's talk with just pointing out a few sources where I think you might find some useful evidence in trying to corroborate your lay client's complaints of undue influence. Evidence in probate claims, obviously, and undue influence claims is no less important and no less essential, despite the fact you're proceeding with influence. And again, whilst the most important witness is no longer able to give evidence, certain documents and third parties can go some way to filling in those blanks. In particular, Key documents will be the will file, any Larkin Nugust response, GP records, death certificates, hospital records, care home records and daily drug charts, social services records, social security records, and also any particular communications with the Court of Protection, and any other documents generated by the testator at a time when the will or codicil was executed. All of that is going to give you something of a window into what was going on at the time. And again, the usual cast of witnesses will be important. Solicitors, doctors, families, friends, carers and neighbours are all going to be of assistance in trying to paint a picture as to what was going on in this person's life when the will was executed. And what should be clear from the authorities is that allegations of fraud and undue influence or forgery are discouraged by the courts, and any party alleging it does face something of an uphill battle. And equally, a party who brings an unsuccessful claim is unfortunately going to face a fairly stiff penalty and costs. That's probably another talk for another day. But, and yet, these cases are out there, and given the right set of facts, the court will be willing to draw the necessary inferences to make a finding that a will was executed by undue influence. And, as we've seen in particular in the Chin case, the courts will be willing to set it aside. So, thank you very much. That brings to a conclusion my end. So.
Right, let me start again now that I've unmuted myself. Your Honour and Chris, thank you very much indeed for fascinating talks on those two key issues. We now have an opportunity for questions and answers. And for those of you who are not familiar with the way that Teams works, if you go down to your screen, you'll see a bar that appears with various options on it. And one of those will say show conversation, and that'll take you to the question and answers. And you have to click on the published section at the top of that, and you'll then see the questions that have been asked. And the first question has been asked by Helen Wynne, who I think has actually had to leave now, but we'll deal with it because she raises an interesting point. And her question is this, and it relates to testamentary capacity. She says testamentary capacity for a will made by a testator versus testamentary capacity for a statutory will. She's recently had a matter with the Court of Protection where both the capacity assessor and Helen herself said that the test was Banks and Goodfellow, yet the OS, that's the official solicitor, said it was the test under the MCA Mental Capacity Act 2005. We did not resolve as the client died. I know this is a grey area and needs judicial clarity, but comments welcome either on or offline. Now, I know that, Your Honour, you touched upon the difference between these two tests in James and James and mentioned that there were identified the differences between the two. But can I perhaps leave it to you to pick up on that question and give us your thoughts?
Very much, Alex. Yes, the problem that we have in this case is that the statutory will process is one which is quite different from the normal process, and there is no, as far as I'm aware, no authority which says that in that context the test is Banks and Goodfellow. The cases which have dealt with the question have been, if you like, ordinary cases where the testator has died and there is then a challenge after the death to the testator's capacity, and Banks and Goodfellow has been held to be the correct test. However, here, where you are considering before the testator's death, obviously, whether the testator has capacity for the purposes of the statutory will's jurisdiction, you are doing it during the testator's lifetime, and there is some support for saying, but I don't think any specific decision, that there it is the Mental Capacity Act which operates. It would be obviously desirable if there were a case to decide that point sooner rather than later, because otherwise there's going to be this continuing argument going on between the two tests. However, it has to be said that although there are some cases where the two tests would provide a different answer, in most cases the answer would be the same.
It's always struck me that the fact that there are two tests, one statutory looking prospectively under the MCA and one common law looking retrospectively, is a bit of an odd situation, and it could lead to the strange kind of situation where someone might be assessed under one test as having capacity and under the other test as not having capacity, but both being on the same day, one being a prospective test carried out at the time and one being the retrospective test carried out later. So you can come up with circumstances, albeit pretty unusual circumstances, where it leads to rather surprising results. But in a way, as you said in James and James, if that's what the government has seen fit to enact, then who are we to argue with it? But there will surely be a Court of Appeal case that comes our way soon on this to resolve the point. There's another point that's been raised by Mark White, which is this: might a testator's long-standing GP be better placed to assess testamentary capacity than, say, an expert, in inverted commas, who has no prior knowledge of the testator? So again, Judge, I think this one's for you.
Thank you, Alex. Yes, this is difficult. Obviously, the GP is going to have more knowledge of the precise characteristics of the testator than any expert who will not have examined the testator during life. On the other hand, the interpretation of what is seen and what is experienced by the testator is going to be better in the hands of the expert who knows something about geriatric, the effects of old age on the ability to deal with intellectual matters. If the GP has got that kind of experience as well, and some GPs do have it, then yes, I would agree. But I don't think that merely because the GP knows more about the patient, having examined the patient during life and can speak to what the actual facts of the matter are, that he couldn't count up to 10, or she didn't remember her name, or the patient thought that the Prime Minister was Margaret Thatcher, or whatever it might be. I don't think the mere fact that the GP's got that information means that the GP's opinion suddenly becomes any better than it would otherwise be. That's my feeling anyway.
Thank you. I've got a point of my own that I'd be interested to raise, which relates to this burden of proof point. When one reads in the textbooks that there is this shifting burden of proof, it leads one to think that one might be able to tempt the judge into deciding a case on the burden of proof, particularly because frequently in these cases the evidence isn't entirely satisfactory. There's grounds to criticise all of the evidence in different ways. And so sometimes one might think, well, I can say to the judge, well, the burden of proof is not being discharged here, and therefore it should be decided on the burden of proof. And there are some cases where they are decided on the burden of proof. But on the other hand, we have that statement in Burns and Burns from the Court of Appeal saying the modern approach is to actually decide things on the evidence. And I'd be very interested to find out, Judge, what your thoughts are on deciding cases on the burden of proof in this area.
It's very much a last resort, is the short answer. Judges, not just because of Burns and Burns, but judges generally don't like resorting to the burden of proof because it suggests you can't make up your mind. You look at the material you've got and you say, this is in favour of the point and this is against the point. Weighing them up, I think that the point is proved, or I don't think the point is proved. And you simply make a decision on the evidence. There are those very, very rare cases where things are so finely balanced in your mind that you just can't push one over the line one way or the other, and then you do have to resort to the burden of proof. But my feeling is I would rather not decide on the burden of proof. I'd rather say, on the whole, I'm convinced by the evidence, or I'm not convinced by the evidence, if you see what I mean. One way or the other, to say that that's my conclusion. And I think that's better for certainly the lay clients involved as well, that they know that that's the judge's decision whether they like it or not.
Lovely, thank you very much. Unless anyone has any other questions, let me have a quick look. Yes, we do. Just give me a moment while I scroll up. So, from an anonymous questioner, following on from Mark White's question, what happens if the estate refuses to agree to the testator's GP providing a report? I don't know whether perhaps should we give this one to Chris so we can share matters out fairly. So Chris, have you come across this sort of situation where the estate is refusing to agree to the testator's GP providing a report?
Thank you, Alex. Well, I've never actually had to get as far as getting into a courtroom to argue about it. I've had cases where executors are cagey about giving you information. I suspect probably because they don't want to fan the flames of litigation, and they suspect that you're on something of a fishing expedition on steroids. But in my experience, if you explain to them the importance of the evidence and the inevitability of a court making an order requiring them to disclose it, that evidence has eventually been forthcoming. So I've not had to do it, but we've threatened it. If it is not forthcoming, I see no reason why you simply can't apply to the court for directions. It's relevant evidence. It's going to be disclosable evidence in the course of proceedings. And it's far more desirable that the evidence comes out now before you actually issue proceedings and go to the cost of issuing a claim and then having it produced in disclosure. So that would be my answer to that.
Yes, I've got a case on at the moment where the GP has been very cagey about coming forward and giving his evidence, to the point where he contacted his governing body and had to take advice from them as to whether or not he should get involved. I think eventually the advice was, you are involved, you can't avoid that fact, so you are going to have to give us some evidence. He then had to decide who he was going to give evidence for, and it's ended up that we've ended up having to subpoena him to get him to court, but we all know pretty much what he's going to say, so that was the way we had to do it. So there are ways and means of forcing people to come to court. The trouble with a subpoena, of course, is that if you are the subpoenaing party, he's your witness, and so it becomes very difficult to then cross-examine him if he starts saying things you don't like. So you have to exercise a certain amount of caution. But that's the only experience that I have. I don't know, Judge, if you want to add anything to this discussion.
Yes.
Can we transfer the live mic, as it were, to the judge? Not sure we can.
Doesn't seem to be. There we are. Yes, I'm in no doubt that in an appropriate case, the court will make an appropriate order to obtain the evidence because of its relevance. I had occasion a while back to deal with a matter which was quite different from this, which involved DNA samples being provided for the purposes of showing parentage in relation to the estate, the devolution of an estate after death. And I think that one can see that the court's attitude is really going to be saying, look, this is evidence, this is material which is going to be helpful. It makes no sense for people to rush into litigation if there is evidence which is going to be obtained anyway, because somebody's going to call the doctor. and it will make a lot more sense and possibly save litigation if it's provided now. So I don't doubt that the court will be looking for a way to try and short-circuit the process by providing that information. Whether it's unlikely to be the case that this is a document which is in the hands of the estate as a disclosable document. In fact, there may not be a document yet at all. It could be a question of asking the doctor to actually provide a document, to make a document. But in an appropriate case, I can't see why there can't be a way of getting that material out into the open at an earlier stage. Obviously, every case turns on its own facts, and I have to see what the arguments are in the particular cases. But I'm sure judges will be sympathetic to that happening.
Right, we now have a question from Alana Toos, who is a neuropsychologist, so it's an interesting angle for us to consider. She asks, when she does a testamentary capacity assessment, she uses Banks versus Goodfellow, but always includes a paragraph in the report of how the assessment would have been judged if Part 2 of the MCA had been used. The process is very similar anyway. So covering both bases, as it were, and presumably most, if not all, of the reports will say whichever test we apply, it ends up with the same result. But I suppose in practice, the question is it sensible to ask an expert who's been called to give expert evidence in a case like this to prepare their report with both tests in mind, so that whichever is applied by the judge, you know that you've got it covered by your expert? Does that seem to the panel to be a sensible approach? Judge, let me go back to you on this.
Yes. That's right, it. That disagrees.
I feel for balance. If we were on the BBC, you'd have a speaker disagreeing, so I probably should disagree just for balance. I suppose the only issue would be, but by setting out both arguments, so doing the best I can to come up with a contrary argument, setting out both tests as an expert, are you possibly leaving yourself open to cross-examination by some difficult, smarmy barrister trying to suggest you've got it wrong? That's the best I can do, offering a contrary and balancing view, although I do agree with you, Judge.
I mean, for my part, it seems sensible, because if any of us are lucky enough to be involved in the case that ends up in the Court of Appeal, and the Court of Appeal then decide that actually it's the Mental Capacity Act that applies rather than Banks and Goodfellow, that means that it's unlikely to then be remitted down for a whole hearing afresh on that basis. So it's got to be a safe approach. I have to say though, Alana, you are, in my experience, the exception rather than the rule. I don't see many expert reports where both tests are applied, and in fact I see quite a lot of reports where just the MCA is applied in a contentious probate case, where in fact it's the Banks and Goodfellow test which is the right test to be applied. So I think your approach has much to commend it, if I may say so. Last question at the moment on the live Q&A is an undue influence question. So for Chris, given the case law, is it almost impossible to overturn a solicitor-drawn will on the grounds of undue influence, chin being on its own facts? So, Chris, is that the conclusion we should draw from your talk?
No, in a word. I would say there are a number of cases which emphasise, simply because a testate or a testatrix goes along to the solicitors, and when is asked, are these your own wishes? Are you being unduly influenced? It's very unlikely that they're going to volunteer, that they are there under the pressure of their son or daughter who's sitting in the lobby or sitting in the car. If the would-be undue influencer has done their job properly, the victim, the testator, is unlikely to appreciate that they're under undue influence, such as their will been overborne by the views of the wrongdoer. So the likelihood is that they will just go in, they will not present any evidence of being unduly influenced, and the solicitor's not going to pick up on it. So I would say simply because the will has been prepared by a solicitor, that doesn't guarantee that it's not open to challenge for undue influence. Now, yes, if the firm of solicitors have dealt with that person for 20 years or more, they know them personally, they know the family dynamic, they know previous wills, and they can go through them and establish there's a settled pattern of giving that hasn't been departed from, and this is just a minor change or an updating change, then yes, it's going to be difficult. But simply the fact that it's a solicitor, if it's a new solicitor, I would say that doesn't really give you any comfort in protecting that will. Over to you, Alex, I think I should say.
Yeah, I mean, I'd just add that with both Schrader and Edwards, they both involved wills made by solicitors, and they were both overturned on the grounds of undue influence. And a common feature of both, well, there were two common features. One was it was quite clear that the judge disliked the defendant as a result of the cross-examination. He obviously came across as a deeply unpleasant fellow. And that, I think, has got to be where you want your judge to be thinking if you're going to be running an undue influence case. But secondly, both of them had said something to the solicitors as the reason behind the will, which turned out to be simply false on the evidence. So, Chris, in your case, you pointed out that in Edwards, the chap had told the solicitors that he had done an awful lot for his parents, whereas in fact it was his siblings who had done all the work for his parents. And I seem to recall in Schrader, the defendant had told the solicitors that he had, out of the goodness of his heart, moved out of his own property and in with his mother to care for her, when it turned out that he'd been made bankrupt and had been thrown out of his house by his trustee in bankruptcy and was having to seek refuge with his mother. So, in fact, although it's very difficult to run an undue influence case where you've got a solicitor-made will, if the solicitor notes reveal that the whole reason, the yarn that's being spun to the solicitor for the reason why the will is being made in the defendant's favour is false, then that can be a very helpful piece of evidence to lead you towards overturning the will on that ground. Good, I think we have covered all of our questions. No, we haven't. No, we haven't. I haven't scrolled down. Anonymous. If a testator was the subject of a court of protection deputyship order at the time when a will was prepared, would that be persuasive when the court assesses capacity at a later date? So I suppose we're imagining a testator who makes a will at a time when a deputy has already been appointed to manage their property and affairs. Would that be persuasive when the court comes to assess that person's ability to actually execute a will at the time? Judge, can I pass this one over to you?
Yes. My initial reaction to something like this would be to say, yes, of course, it's going to be of evidential value to know that someone is the subject of a COP deputyship at the time the will's prepared, but it's certainly not going to be conclusive, because it's perfectly obvious, as shown by the case of Park and Park, that you can have people losing mental capacity and acquiring mental capacity backwards and forwards at relatively short notice. And we all know that there are old cases of people who were judged to be suffering from mental illness, who had a lucid interval and made a perfectly valid will during it. It will obviously alter the dynamics of the situation, and it is something that the court will have to take into account, that at a certain date, which might be some months earlier or even years earlier, you never know, the court felt that it was appropriate to put a deputyship in place. That somehow not tips the balance, but it makes the court examine very carefully the question whether, in fact, the testator, the deceased, had capacity at the time of preparing the will. It's something to take into account.
Good. We've reached the end of our questions, and it's also 1:15, so it's a good time to draw things to a conclusion. I would like to thank both of our speakers. Thank you very much indeed for your excellent talks on these two important subjects. We really are very grateful to you both, and in particular, Your Honour, Judge Paul Matthews, for coming in and gracing us with your presence on these points. I hope that you've all found it as useful as I have, and thank you very much, all of you, for attending this talk. We are hoping that our future STEP contentious probate talks will resume in the normal in-person format, so we can actually have drinks and canapes afterwards, as we used to do pre-COVID. So at some point in the future, when it's all calmed down, we look forward to sharing a drink and a canapé with you at some stage. But until then, we wish you farewell. Thank you very much indeed.